entered appearance, full stop para. Registry to appoint a legal aid counsel to appear on behalf of the respondent number 2. Full stop. Let a copy of the paper book be served upon the said counsel in advance. Full stop. List as requested, list for hearing on 19th of February.
Obliged, Lordship.
Your Lordship. I'd like to mention item number 3. My senior counsel is out of session, so this item may be adjourned for.
Here for the respondent.
Yes.
Your Lordship, I'm for the petitioner, appellant, Your Lordship, in this case, when I thought the IA condemnation of 12 people, this will be condemned today.
Okay. Have you filed your objection in the
They
IA?
have already filed.
How much delay?
344 days.
If he wants to have it represented by a senior, made an objection. When are you praying for?
It may
Do you
be,
have any serious objection in the delay condemnation?
no.
Then we can condemn the delay perhaps.
Yes, yes.
Let that matter reach, okay?
Okay. Deeply obliged.
Be here when the matter is called upon. Item 1. Mr. S.K. Deori. S.K. Deori, K. Dabi, Sumila.
Lordship, I am for NHPC and I have received the Wakalatnama yesterday.
WA 23, the NHPC is a party.
Yes.
Okay. Have you filed your wakalatnama?
No, it's in my hand now. I will file today.
None appears for the petitioner on appellant on call. Full stop. Whereas Sri K. Kamduk, Standing Council, Plan Management, and Ms. Wangmu, the State Council, are present. Full stop. Para. Sri K. Saxena, Learned Council, has submitted that he has been instructed to appear on behalf of the respondent number. On the behalf of the
Number 2
respondent.
and 3. 2 and 3.
Numbers 2 and 3, that's NHPC. And would be filing the formal wakalat number
Today.
during the course of the day. Full stop. Para. In the interest of justice, list after 2 weeks.
No, Lordship, can it be on 13th? 13th of February.
In the interest of justice, matter is adjourned to be listed on 13th. 2.
Obliged.
Item 2, why is it listed today?
Your Lordship, though it was admitted, Your Lordship.
It has been admitted.
Yes, Your Lordship. However, the service upon the informant, Your Lordship, it has come as unserved that, and they could not find the addressee, Your Lordship.
Served or not? Not served.
Not served, Your.
Have you tried through the consent OC?
No, Your Lordship. The first notice was through the registry.
Though this appeal was admitted on 7/11/2023 and paper book has also been prepared, it appears that the respondent number 2, that service upon the respondent number 2 is not yet complete. Full stop. There is an office note dated 23/11/2023 whereby it has been reflected that the notice upon the respondent number 2 has returned unserved as the addressee was not found in the given address, full stop. The notices were routed through the office of the learned CJM, UPR, full stop, para, in view of the above, race is directed to appoint
Yes.
a legal aid counsel to appear on behalf of the respondent number 2. Full stop. Consequently, all the related documents, including the paper book, be furnished to the said amicus curiae. Full stop. List after 2 weeks.
Nice.
List after 3 weeks.
May I, Your Lordship, I'm extremely sorry, Your Lordship. They have taken consent from a senior actually, Your Lordship, for the adjournment of this matter, Your Lordship. I was unaware of this.
My lord, I have a very strong objection. Last time also I have raised objection. My lord, what happened in this case? Now this appellant, he lost in a single bench. And in compliance with single bench, my lord, his promotion was, my lord, withdrawn and he was returned back to his original place, my lord. So against that, he filed a writ petition without challenging the single bench order, my lord. And there is a stay order saying that, my lord, he also prepared the appeal, which is pending before the division bench. As on today, my even condonation of delay is not accepted, my lord. But this is the position, my lord.
Now
I
you
think-
filed an application for vacating stay in the writ petition.
I
Matter is
think-
there.
But the to so
Your
knows, my lord, this is the misconduct, but I don't
no,
expect all these things, saying all these
Your
things, my
strong
lord.
objection has to be expressed before the appropriate bench, not before us. Your strong objection, very stronger objection.
My lord,
File an application for vacating stay. That instead of challenging the root cause of the order, just file a writ petition. We'll
my lord, plea was taken,
we'll give a short date.
my lord.
Monday?
Any, date, my lord, no issue.
Monday. Okay. A prayer for adjournment has been made on behalf of Sri Mukpatil.
Yes.
Then Senate Council. Full stop. Para.
My lord, your lordship may kindly say no more further adjournment, my lord.
Sri
I am not
R.H.
again there,
Rambam,
my lord.
the learned AAG, however, submits that the matter is urgent. Full stop. Considering the above, that this a short adjournment is granted, directly listing of this matter on Monday.
My lord.
Obliged.
Monday on the 5th. Huh? 5th. Yes.
May it please, Your Lordship. No, this is a matter within the pre-2016 pensioners. They are before Your Lordship, my Lord. They are basically aggrieved by denial of revision of their pension by following formulation 1 by the central government, my Lord. Lord, what happened in this matter? The central
Your pre what? Pre?
pre-2016 pensioners.
Yes.
Milord, what happened in this matter? The central government, Milord, come up with an OM.
Your state government employees.
Yes, Milord, all retired, Milord. Milord, the central government come up with an OM formulating a committee to recommend how to revise the pay of the pensioners, Milord, for the central government employees. Then that committee recommended, and pursuant to that, an OM was issued by the central government, by which, my lord, 2 formulations were given. Formulation 1, formulation 2. And in the said recommendation, it was also said that the formulation 1 will take some time. So for the moment, you follow formulation 2 and give the benefit to the employees. So far as the formulation 1 is concerned, another committee was formed. That committee is to decide and give its recommendation. And accordingly, that committee was formed and gave it recommendation how the formulation 1 will be implemented. Now, Government of Arunachal Pradesh, my lord, following accepted the OM issued by the central government in toto, my lord, in totality, and given the interim relief by following formulation 2. But so far as formulation 1 is concerned, when the central government said that you are now to implement for central government employees, that you are now to implement the formulation 1, the state government, my lord, did not do that. They just sit tight over the matter. And this is the entire gamut of the case, my lord. I'll just take your lordships with the documents.
Why don't you read this judgment?
Yes, my lord.
That will clear everything.
Yes. Judgment, your lordship will find it starts from page 165, page 166, my lord.
Yes,
May I read?
yes, please.
Para 2. This writ petition under Article 226 of the Constitution of India is instituted by the petitioner seeking the following reliefs. Serial number 1, to direct the state respondents to revise the pension of pre-11-2006 family pensioners stroke family pensioners in terms of the decision of the Government of India, White Office Memorandum dated 12/5/2017, towards implementation of the government's decision on the recommendation of the 7 CPC on revision of pension of pre-2016 pensioners, retirees, as per formulation 1 of item 11 of resolution number so-and-so dated 4/8/2016. And to direct state respondents to pay the arrears of revised fixed medical allowance to the pre-11-2006 pensioners, family pensioners of the Government of Arunachal Pradesh for the period from 1/7/2017 to 31/3/2018. The background facts leading to the filing of the present writ petitions are numbered as under. In the year 2014, the Government of India had appointed 7th Central Pay Commission with specified terms of reference. Accordingly, the 7th Pay Commission had submitted its report on 19/11/2015. Thereafter, the Government of India, after due consideration, has accepted the report of the Commission, White Resolution number so-and-so dated 4/8/2016. Thereafter, on the same day, the Government of India has issued one office memorandum, so-and-so A Roman 2, for implementation of the decision of the government on revision of pension of pre-2016 pensioners stroke family pensioners in terms of formulation 2 as contained in item 11 of the Government of India resolution dated 4/8/2016. Thereafter, on 12/5/2017, the Government of India, Department of Pension and Pensioners Welfare, New Delhi, had issued another office memorandum dated 12/5/2017, giving effect of refixation of pension of pre-11-2016 pensioners, family pensioners, based on formulation 1 of item 11, as recommended by the 7 CPC. The Government of India, Ministry of Finance, Department of Expenditure, had issued another office memorandum dated 14/7/2017, revising the fixed medical allowance from 500 to 1,000 payable with effect from 1/7/2017. The Government of Arunachal Pradesh also, instead of appointing a pay commission, used to implement the report of the Central Pay Commissions so constituted by the Government of India. Thereafter, on 16/1/2017, the Government of Arunachal Pradesh also adopted the office memorandum dated 4/8/2016 and issued one office memorandum dated 16/1/2017, and the same was published in the Arunachal Pradesh Gazette and extended the benefit of revision of pension of pre-11-2016 retirees in terms of formulation 2 as contained in item 11 of Government of India resolution dated 4/8/2016. But the Government of Arunachal Pradesh has not extended the benefit of refixation of pension of pre-11-2016 pensioners, family pensioners, based on formulation 1 of item 11 as recommended by the 7 CPC in the similar line with the notification dated 12/5/2017 issued by the Government of India, Department of Pension and Pensioners Welfare, New Delhi. Apart from this, the Government of Arunachal Pradesh has also not paid the arrears of revised fixed medical allowance to the pre-1/1/2016 retirees for the period from 1/7/2017 to 1/4/2018 at the rate of rupees 1,000, even though policy decision on the same was announced by the Finance Minister of Arunachal Pradesh in his budget speech on the floor of the House on 12/3/2018. However, the Government of Arunachal Pradesh, by issuing one office memorandum dated 5/10/2015, the family pensioners of Arunachal Pradesh government were paid fixed medical allowance of rupees 500 per month retrospectively with effect from 1/12/2014. The present petitioner number 1, which is an association of Arunachal Pradesh state government pensioners, had filed several representations to the state government functionaries for implementation of formulation 1 of item 11 as recommended by the 7 CPC, and also to fix medical allowance of rupees 1,000 per month. But they received no response from the government. Being aggrieved, the petitioners approached this court by filing the present writ petition seeking relief as aforementioned. The respondent number 1 had filed affidavit in opposition denying the averments made in the petition. It is stated that though the Government of Arunachal Pradesh has adopted the recommendation made by 7 CPC, yet it has not implemented the said recommendation in toto. And due to acute financial constraint, the government has decided to implement formulation 2 of the 7 CPC wide OM dated 16/1/2017, and the state has a liberty to implement and not to implement any of the recommendation made by the 7 CPC. Considering its financial capacity as well and as per law, and the matter is within the administrative domain of the state government. And as such, the prayer made by the petitioners in this petition are not maintainable, and it is therefore contented to dismiss the petition. The respondent number 1 also filed one additional affidavit stating that the medical allowance of rupees 1,000 with effect from 1/4/2018 is being paid to pensioners despite financial constraints. The petitioner number 1 had filed their affidavit in reply, and the respondent number 1 also filed its reply to the affidavit in reply of the petitioners, denying the averments made therein. In the counter affidavit to the additional affidavit of the petitioners, the respondents had stated that though the government has extended the benefit of medical allowance to the petitioners, yet same is from 1/4/2018, not from 1/7/2017, and thereby denied the dues of 9 months of arrear to the petitioners. Sri So-and-so Learned Counsel for the petitioners submit that the petitioners are the Association of Retired Pensioners of Government of Arunachal Pradesh, and Government of Arunachal Pradesh has refused to revise the pension of the petitioners with effect from 1/1/2016 as per formulation 1 of item 11 of resolution dated 4/8/2016, by which the Government of Arunachal Pradesh has decided to implement the recommendation of the 7 CPC. Mr. So-and-so submits that and the office memorandum dated 4/8/2016 was succeeded by another OM of the Government of India of the same date, that is 4/8/2016, for implementation of the decision on revision of pension of pre-2016 retirees in terms of formulation 2, as contained in item 11 of the Government of India resolution dated 4/8/2016, as an interim measure, pending completion of necessary computation for revision of pension as per formulation 1. Mr. Patil further submits that the Government of Arunachal Pradesh wide OM dated so-and-so adopted the OM dated so-and-so of the Government of India and revised the pension of pre-1/1/2016 as per formulation 2 as an interim measure. But formulation 1 has not been adopted by the Government of Arunachal Pradesh, though the Government of India has extended the benefit as per the formulation 1 wide OM dated so-and-so, and thereafter by another OM dated 12/5/2017, the Government of India has refixed the pension of pre-1/1/2016 pensioners based on formulation 1 of item 11 of resolution of Government of India dated 4/8/2016. But the Government of Arunachal Pradesh has not taken any step till date for refixation of pension of pre-1/1/2016 retirees based on OM of Government of India dated 12/5/2017. Mr. So-and-so further pointed out that the Finance Minister of Government of Arunachal Pradesh in his budget speech in the floor of the House on 12/3/2018 had announced medical allowance to the pre-1/1/2016 retirees for the period from 1/7/2017 to 1/4/2018. And despite the government of AP had not given the arrear thereof, and therefore Mr. So-and-so contended to allow this petition by directing the respondents to extend the benefit to the petitioners as per formulation 1 of the OM of Government of India. Per contra, Mr. So-and-so, learned senior advocate Yes. Accepting and rejecting the recommendation of the 7 CPC is in the administrative domain of the state, and it is the policy decision of the government, and the court ought not interfere with the same. In support of his submission, Mr. So-and-so has referred to decisions, one of this Honorable Supreme Court, one of the Honorable Supreme Court in MP Rural Agriculture Extension Officers Association versus State of MP and others, reported in 2004 SSA 646, and another decision of this court in State of Arunachal Pradesh versus Bamar Yino, reported in 2016 2 GLT 1207. Mr. So-and-so has relied upon paragraph 28 of the decision of the Honorable Supreme Court in Census Commissioner and others versus R. Krishnamurthy, reported in 2015 2 SCC 796, wherein referring to its earlier decision in N.D. Dayal versus Union of India, reported in 2004 9 SCC 362, the Honorable Supreme Court had observed that in the matter of policy, where the government has taken a decision bearing in mind several aspects, the court should not interfere with the same. Honorable Supreme Court also referred to another decision in Narmada Bachao Andolan versus Union of India, reported in 2010 SCC 664, where it has been held as under para 229. It is now well settled that the courts in exercise of their jurisdiction will not transgress into the field of policy decision. Whether to have an infrastructural project or not, and what is the type of the project is to be undertaken, and how it has to be executed are the part of the policy making process, and the courts are ill-equipped to adjudicate on a policy decision so undertaken. The court no doubt has a duty to see that in the undertaking of a decision, no law is violated and people's fundamental rights are not transgressed upon except to the extent permissible under the Constitution. Mr. So-and-so further submits that the state government will definitely extend the benefit of formulation 1 to the pensioners as and when the financial condition of the state will improve, and that the medical benefit as per recommendation of the CPC has already been extended to the petitioner. Therefore, Mr. So-and-so contends to dismiss the petition. In view of the assertions made in the pleadings of the parties and also in view of the submissions so advanced by the learned advocates of both sides, the question that has arisen for consideration of this court are formulated as under. Number 1, whether recommendation made by the 7 CPC is binding on the government of Arunachal Pradesh, and whether it creates any legally enforceable right to the petitioner to get the same implemented. Number 2, whether the court can interfere with the policy decision of the government in respect of implementation or non-implementation of recommendation of pay commission and issue the mandamus. Having regard to the submission of learned advocate for both sides, I have carefully gone through the pleadings of the parties and also gone through the documents placed on record and further perused the case law referred by Mr. So-and-so. Indisputably, the government of Arunachal Pradesh, instead of appointing separate pay commission, used to accept recommendation made by the Central Pay Commission and extend the benefit to its employees. And sometimes it accepts the recommendation in toto and sometimes with certain modifications. In the year 2014, the central government has appointed 7 CPC with specified terms of reference. And accordingly, the 7 CPC has submitted its report on 19/11/2015. Thereafter, Government of India, after due consideration, has accepted the recommendation of the Commission, White Resolution dated 4/8/2016. Thereafter, on the same day, the Government of India had issued OM dated 4/8/2016 for implementation of the decision of the government on revision of pension of pre-2016 pensioners, family pensioners, in terms of Formulation 2, as contained in item 11 of the Government of India resolution dated 4/8/2016. It also appears that in the same line, the Government of Arunachal Pradesh also on 16/1/2017 has adopted the OM dated 4/8/2016 issued by the central government and issued one OM, and the same was published in the Arunachal Pradesh Gazette and extends the benefit of 7th Pay Commission as per Formulation 2 of item 11 to its pensioners. Further, it appears that on 12/5/2017, the Government of India, Department of Pension and Pensioners Welfare, New Delhi, issued another OM dated 12/5/2017, affecting refixation of pension of pre-11/2016 pensioners, family pensioners, based on Formulation 1 of item 11 as recommended by the 7 CPC. Thereafter, the present petitioners have filed several representations to the state government functionaries for implementation of Formulation 1 of item 11 as recommended by the 7 CPC, and also to extend the medical allowance to the pensioners at the revised rate. Thereafter, on 5/10/2015, the Government of Arunachal Pradesh, by issuing one OM, the pensioners and family pensioners of Arunachal Pradesh government were paid fixed medical allowance of rupees 500 per month retrospectively with effect from 1/1/12/2014. But the Government of India, Ministry of Finance, Department of Expenditure has issued one OM on 14/7/2017, revising fixed medical allowance from 500 to rupees 1,000 payable with effect from 1/7/2017. But such benefit was not extended to the petitioners by the Government of Arunachal Pradesh. Further, it appears that Finance Minister of the State of Arunachal Pradesh, in his budget speech dated 12/3/2018, has announced in the floor of the House that the revised fixed medical allowance will be disbursed with effect from 1/7/2017. But on 10/7/2018, the Government of Arunachal Pradesh has issued one OM revising fixed medical allowance of rupees 1,000 per month with effect from 1/4/2018, not from 1/7/2017, as per commitment given in the floor of the House. Now coming to the issue number 1, so formulated above, I find that Sri So-and-so has categorically submitted that the recommendation of the Pay Commission is not binding upon the government, and government has the option to accept the same in its entirety or partially, or not to accept it. And it is the policy decision of the government. The proposition of law regarding the nature of recommendation of Pay Commission is well settled by the Honorable Supreme Court in Catena of decisions. The Pay Commission recommendations are binding or not, and whether court can interfere with any policy decision of the state government, my lord. Now, I'll just take your lordships with the documents, what actually happened in this matter. Lordship will kindly come to page 76 for a moment. This is the resolution dated 8 September 2015. prior to that, my lord, will kindly come page 74.
7-4.
74, my lord, annexure 2 of the writ petition. This is the, I'm sorry,
Gazette.
no, this is the, my lord, Finance Ministry, Department of Expenditure, Office Memorandum, come resolution.
This is a Gazette notification.
Yes, my lord, it's a gazette notification.
So this is the constitution of the board.
Yes, constitution of the board.
Oh, board.
I'll take your lordships, what responsibility was entrusted upon the commission?
No, we did not go to those aspects.
All right,
But
I'll take
committee
your
was,
lordship directly.
these are understood. Committee was framed.
Committee was formed, yes,
Then
thereafter, my
they
lord,
gave two formulations.
fine, my lord,
One
fine,
would take time.
fine,
For a
fine.
temporary period, implement two. Another committee for one. They made
Yes.
further recommendations how to implement one.
Yes.
One has not been implemented.
Yes, ma'am.
And so far as the announcement in the floor of the house was concerned, their explanation is that it has been given, but from a subsequent date,
Yes, ma'am.
from 1/4/2018. That is
Yes.
the case.
Yes. So, if your lordships kindly come to page 78,
7-8.
yes. Yes, annexure 3.
Yes.
This is the terms of reference of 7 CPC.
matter.
Normally it come
That doesn't
immediately.
matter. We have
Yes,
16 days, not a problem.
yes, my lord. Implementation of government's decision on the recommendation of the 7th Central Pay Commission, revision of pension, family pension of pre-2016 pensioners, family pensioners. In pursuance of the approval of the government of Arunachal Pradesh, a copy of OM number so-and-so dated 4/8/2016 issued by the Government of India Ministry of Personnel, Public Grievance and Pension Department of Pension in the government rupees 2,50,000 with effect from 1/1/2016. This is replica of the government of India's OM. May I just take your lordships to the government of India OM for a moment? So this is how the government of India's OM was adopted. 4/8/2016 is the government of India OM that starts from page 78. And relevant portion, my lord will find, lordships will find at page 82. These are the two formulations, my lord. My lord, page 17. I'm sorry, my lord, this is not the OM, this is the resolution of the government of India. I'm sorry, my lord. Page 82.
What is 1882?
Page 82 is the part of the resolution wherein the recommendation of the 7 CPC is there as to how to, this formulation 1 and 2, my lord. Both the formulations are there.
Eighty-two, yes.
Page 82. ma'am. Revision of pension of pre-7 CPC retirees. The commission recommends the following pension formulation for civil employees, including CAPF personnel who have retired before 1/1/2016. Now this is formulation 1, my lord, first one. All two arrived at an alternate value for the revised pension. Whatever I was getting at the time of 6 CPC pension, that into 2.57. This is the second formulation. Number 3, pensioners may be given the option of choosing whichever formulation is beneficial to them. They'll be given option. It is recognized that the fixation of pension as per formulation 1 above may take a little time, since the records of each pensioner will have to be checked to ascertain the number of increments earned in the retiring level, it is therefore recommended that in the first instance, the revised pension may be calculated as at 2 above, that is formulation 2. And the same may be paid as an interim measure. In the event calculation as per 1 above yields a higher amount, the difference may be paid subsequently. Now, what is the decision of the government, my lord? In the next column. 82 itself, in the next column. Right hand side, my lord. Both the options recommended by the 7th Central Pay Commission as regards pension revision be accepted subject to feasibility of implementation. Revision of pension using the second option based on fitment factor of 2.57 be implemented immediately. The first option may be made applicable if its implementation is found feasible after examination by the committee comprising of secretary pension, a chairman, member staff, railway board, member staff, Department of Post, additional secretary, and financial advisor, Ministry of Home Affairs and Controller General of Accounts as members. So 2.57 formulation 2 will be implemented immediately, and the feasibility of formulation 1 will be considered by another committee. Now, if your lordships kindly come to the office.
Discuss page 82.
Yes,
Two options were given. Two formulation rather.
yes,
The second was very easy to implement. It
yes,
was just multiplied by 2.57.
yes,
And the employees were to be given an option. You want one or you want two. If
beneficiary.
somebody opts for two, and in the actual execution and implementation of one, it is found that one is more beneficial, then the difference has to be given to persons who have opted for two.
Yes,
There may be persons who can opt for one also.
yes, nobody will opt
No.
for two because,
No, there
One
are,
is-
because see, there is a clear stipulation.
yes,
Pensioners may be given the option
option
for
choosing whichever,
population is
yes,
beneficial to
whichever
them.
benefit.
Pension revision be accepted subject to feasibility of implementation, number one.
Yes,
That's the first caveat.
yes,
Second, another caveat is there. First option may be made applicable if its implementation is found feasible after
Yes.
examination by the
lordship
committee
is reading, my lord.
at page 82 itself.
Yes, serial number,
Second column,
yes,
both the
Yeah.
options
yes, my lord.
recommended by the 7P ACPC as regards pension revision be accepted subject to feasibility
Yes, my lord.
of the implementation. That's the first
Implementation, revision of
caveat.
pension,
Then second caveat, revision of pension during using the
Second
second
option.
option based on the fitment factor.
Immediately.
2.5 will be implemented immediately. First
Yes.
option may be made applicable if its implementation is found feasible after examination by the
by
committee.
committee. Committee examined and, my lord, the central government had issued an OM. That they are not implementing, my lord. That is the issue. So before going to that OM, my lord, which OM ultimately provided, page 84 will give your lordships some idea because this recommendation, this resolution was implemented by this page 84. Ultimate order is page 84, 4 August 2016. This was accepted by the government of Arunachal in the Gazette notification.
No, 4860 2016 is also the same page 78. What was 78? Is it the same date?
Yes, my lord, same date. Both are same date, my lord.
78.
78 is the resolution and 84 is the decision, same date.
This OM is pursuant to that resolution. After that resolution, the OM followed as circulation.
Sorry, my lord.
After the resolution,
Yes.
it was circulated by means of this OM.
Yes. So this is the final decision of the central government, and this decision was accepted by the government of Arunachal Pradesh, my lord. In their Gazette notification, reference has been made for this OM, my lord.
Okay.
May I read, my lord? The undersigned is directed to say that in
No,
pursuance,
it is okay, but this is not required. Where is the acceptance?
I'm just taking it the relevant portion, my lord.
Not required, not required. Where is the acceptance by the state government?
State government accepted at page 89. I am referring this to your lordships only to indicate the decision of what was the decision of the central government, and that decision was accepted in totality by the government of Arunachal Pradesh. So para 4.1 page 85, it was provided that 2.57, it will be done. Illustrations are given. How 2.57 will be done.
Those nitty-gritty we may not require, it may not be required
Lordship,
for
I am just
go into.
placing
Let us
the,
see 89, let us see again 89.
now if your lordships kindly come, what is the important provision is page at 87 clause 11. This is where we are harping, my lord. Page 87 clause 11, it provides lordships got it, no? Clause 11, further orders in this regard to revision of pension based on the recommendation of the committee to be constituted in terms of the government decision on item 11 of the department's resolution dated 4/8/2016 will be issued in due course. That is, the committee formed to take a decision on formulation 1. This is. Further orders in regard to revision of pension based on his recommendation of the committee to be constituted in terms of item number 11 of the resolution, my lord.
Where is item number 11?
That your lordships just referred, page 82. The committee was formed to see the feasibility to implement formulation 1. The first option may be made applicable if its implementation is found to be feasible after
No,
examination.
where do you get 11? Oh, 11 is the.
Yeah, top left hand. By the central government was accepted by page 89 by the government of Arunachal.
Where is the committee's recommendation?
Yes. Committee's recommendation also will find page 90, Annex 6.
90.
Yes, my lord. My lord, page 90 is not the committee's recommendation. Page 90 is the ultimate decision of the central government after the recommendation of the committee. Committee was constituted, committee recommended, and this was the decision of the central government by virtue of an office memorandum. 12 May 2017, my lord. May I read, my lord? The undersigned is directed to say that the Central Pay Commission in its report recommended two formulations for revision of pension of pre-2016 pensioners. A resolution number so-and-so dated 4/8/2016 was issued by the department indicating the decisions taken by the government on the various recommendations of the 7 CPC on pensionary matters. Based on the decisions taken by the government on recommendations of 7 CPC, orders for revision of pension of pre-2016 pensioners, family pensioners in accordance with second formulation were issued by this department's OM dated 4/8/2016. It was provided in this OM that the revised pension, family pension with effect from 1/1/2016 of pre-2016 pensioners, family pensioners shall be determined by multiplying the pension, family pension as has been fixed at the time of implementation of the recommendation of 6 CPC by 2.57. In accordance with the decision mentioned in department's resolution dated 4/8/2016, that is page 82, and OM dated 4/8/2016, the feasibility of first option recommended by 7 CPC has been examined by a committee headed by Secretary, Department of Pension and Pensioners Welfare. The aforesaid committee has submitted
It
its...
is okay, this is the OM by the central government after consideration of the committee's report on formulation 2.
Yes. Now, what ultimately decided how to fix the under formulation 1, that has been given in para 4, my lord. The aforesaid...
That we have seen, that is the, it's a replica of what has been.
No, not exactly replica. The slight difference is there, my lord, because actually committee found in in formulation 1 in one aspect that increments or in totality, you cannot say that clause 11 I will not implement, I will implement clause 4 only, my lord. You have accepted it entirety, and this change is inevitable. This change was already there. It is not that
The acceptance is at page 89.
89, my lord. Acceptance is page 89. So once you accept that clause 11 of the OM of 2016 as well as the entire OM, consequently you are bound by this, and you are supposed to give this benefit to this retired person, my lord. You are not implementing. So my humble submission is that two questions formulated by Honorable Single Judge, both the questions are not relevant to issue, not relevant to issue to determine the issues involved herein, my lord. No further policy decision is required. Policy decision already there. And where is
Are
the
you contending that you were not aggrieved by any policy decision? Rather, you had wanted for implementation of the-
implementation of the decision? And one more thing I'd just like to point out before your lordship. Lordship will kindly appreciate by, my lord, not giving this benefit of this subsequent OM or as per formulation 1, what will happen? What is the consequence, my lord? The pre-2016 pensioners, they'll get how? Last pension into 2.57. And post-2016 pensioners, they will get their pay revised they'll get their pay revised because they'll retire after 1/1/2016. So their pay revision will be effective. And on that, revised pay revision, their pension will be fixed. So two different criteria has come up from 1/1/2016. Because Lordship is aware, law laid down by the Honorable Apex Court that all pensioners are part of one homogeneous group, my lord.
No, cutoff, we cannot interfere with cutoff date.
No,
Somebody
I'm
may
not-
be, somebody may be deprived, we are not on that. That somebody gets the benefit of a revision, he
No.
must have retired earlier. In
No,
that
no.
case, all persons retiring will have to be given benefits of all revision.
No,
That's
no, no,
not-
I'm not on that, my lord. That's why I tried to take your lordship's.
You
request.
cannot put all the pensioners in one homogeneous class,
No,
no.
No, that is my submission only, my lord. What I'm trying
It
to,
cannot be, it cannot be a practical submission. One has severed his ties with the government.
that is what,
Employer-employee relation is not there. How can you get the benefit? Unless the benefit is given with retrospective effect by the government. That is done in most of the cases. 2 years, 3 years retrospective effect.
so,
But for a cutoff, we are not going to, that law
no,
is
it is,
clear.
there is no cutoff
no.
as of such.
For this segment, you did not argue, we will not be accepting that another class has come up who was retired post 1st of the January 2016.
My lord, I am
But
not,
on the first part, we have understood, yes.
yes, ma'am.
I think that is your case.
That's, my lord, first argument is that, my lord. And second argument that just for one line, I'll
Yes.
just put, my lord. I am not on cutoff, my lord. I am not on what amount the pre-2016 got or post. I am on the, my lord, formula. You cannot apply two different criterias, my lord. Amount may be different. Earlier one may get lesser amount, next one may get higher amount. But two criterias you cannot follow. The criteria has to be one. And that honorable.
What
Apex
is the
Court-
change in the criteria for post for post
My lord,
2016?
for that, my lord, I wanted to take your lordships with that para 4 of page 19. My lord, what the formulation one, the government of India.
Okay, this may not, we may not be interested. Yes, first one.
May it please your lordship, my lord. My lord, first of all, my lord, it's fallacious on the part of the petitioner to understand that state government has accepted formula 2, my lord, by notification 2017, my lord. May I just take your lordship to that notification, my lord? Page 89, my brother has referred, my lord.
89.
Yes, my lord.
Yes, please.
My lord, this is the notification by which we have accepted the Formula 1. That is the submission made by my lord friend, my lord. Has your lordship got it, my lord?
Yes, yes.
My lord, it's a starting paragraph, my lord. In pursuant to the approval of the government of Arunachal Pradesh, a copy of OM dated number so dated 4/8/2006 issued by the government of India. My lord, this 4/8/2016, my lord, your lordship has seen, my lord, is basically for Formula 1, my lord. My lord, wherein my lord, option has been given that Formula 2 will be applied after exercise of something, my lord, by the expert committee. Now, interesting, my lord, when the
No.
You are saying the
Wrong.
reverse.
Vice
My lord.
versa.
Formula 2 would be immediately implemented.
Yes.
One will be implemented after the committee.
Yes, my lord, after examined by the expert committee, my lord. Yes, my lord. Now, your lordship may kindly see the date, my lord. Now, the 16th January 2017, this is the office memorandum issued by the government of Arunachal Pradesh accepting that formula, my lord.
You are referring to 89.
Yes,
Please read.
my lord. In pursuant to the approval of the government of Arunachal Pradesh, a copy of OM number so and so dated 4/8/2016 issued by the government of India. Government of India, Minister of Finance, Public Grievances. My lord, see the date, my lord. 4/8/2016.
Yes.
May I just take it to
That
4/8?
is the office memorandum of the central government,
Yes, my lord.
which is at page.
First is mother regulation, then another is office
One
memorandum.
is at page 84.
Yes, sir. 78 is the memorandum, my lord, regulation, my lord.
This is 84.
Yes, my lord. Then,
OM is at 84.
yes, my lord. 84 is the office memorandum, my
Right,
lord.
right.
Your lordship see the date is same, my lord.
Yes.
Regulation date,
Yes,
office,
yes.
yes. Now, the state government date is, my lord, 16 January 2017, no disputed, my lord. when we have adopted, my lord.
16 January 2017, yes?
Yes, my lord, page 89, my lord.
Yes.
Now, the interesting part is, my lord, when this Formula 1 was accepted, but accepted or the central government accepted the recommendation of the expert committee. See the date, my lord. 12 May 2017, my lord.
Where?
Your lordship may kindly see the page 90, my lord. My brother just referred, my lord. When the expert committee was recommended was accepted, then the office memorandum issued by the central government, my lord. Accepting the another formula, my lord.
Where page?
Top, my lord. Office memorandum, top, your lordships will find the right hand side, my lord. Third floor, Loknath Bhavan, Khan
No,
Market,
you are
New Delhi,
referring to
dated 12 May 2017.
Yes.
And
Okay.
see the date of the state government notification, 16 January 2017, man. How he can say that we have accepted the formula, man? This is wrong submission, man. The dates are totally different, man. This talks about the first formula which we have accepted, my lord, because that was feasible to us, my lord. So it is a wrong submission that we accepted, my lord. There is a cabinet decision to accept the second formula, my lord.
No, my submission.
No, you have submitted that. That state government accepted, my lord, based on the expert committee, my lord. That is a wrong submission, my lord. Now this demonstrates, my lord, we never accepted, my lord. Because there will be lots of financial implication, my lord. Not only pension, my lord, their pay revision will be there. Based on the pay revision, there will be, again, my lord, calculation of, my lord, their beneficiary, my lord. That is the reason, my lord, that we have not accepted, my lord. So there is no any informative, my lord, in other parts by the land is single batch, my lord. And so far, my lord, issuing mandamus in financial matter, it is well settled, my lord. Page 89 and 90. But this makes the picture clear, my lord. Yes, my lord. One is January, one is May, my lord. Now, my lord, I asked my friend, my lord, is there any notification? I'm sorry.
Yes.
Now, my lord, I asked my friend if we can produce any notification pertaining to this after 12 May 2017 from the state government. Then, my lord, yes, he may. But so far, my instruction it goes, my lord, there is no such notification, my lord. Accepting this OM dated 12 May 2017, my lord. So that makes very clear, my lord. We never accepted that. Had there been any discrimination? Yes, my lord, they have a point, my lord. There is no any discrimination. We never implemented, my lord. So therefore, my lord, there is nothing wrong, my lord. There is no infirmity, my lord, in the other parts with
Mr. Nabam,
my lord, my lord.
can you read the first part of paragraph 4 of page 90?
90, paragraph 4, my lord.
The aforesaid committee
My lord, the aforesaid committee has submitted its report and the recommendation made by the committee have been received by the government,
considered.
considered by the government. Accordingly, it has been decided that the revised pension, family pension with effect from 1/1/2016 in respect of all the
All
central
can- centrals.
All the centrals, my lord.
Okay, is there any further observation that appropriate government, it will also be applicable state government?
No, it cannot, my lord, it cannot, my, because it's pay
Then
commission
we are-
basically for
no,
the
we
central
are-
government, my lord.
Whether they can or cannot, we are not asking.
My lord,
Whether there is.
yes, my lord. May be revised by normally fixing their pay in pay matrix recommended by the seven CPC in the level accordingly to the pay in the pay scale / pay band and the grade pay at which they retire or died. This will be done by national pay fixation under each intervening pay commission based on the formula for the revision of pay. While fixing pay on national basis, the pay fixation formula approved by the government and other relevant instruction on the subject in force at the relevant time shall be strictly followed. 50% of the national pay as on 1/1/2016 shall be revised.
Okay,
Pension.
we have read.
So, my lord, there is no any whisper that is state government also, nothing like that, my lord. I think, my lord, our state government stand is very clear, my lord. Yes, my lord, we never adopted, my lord. And there is no any such notification.
My lord, I'd just like to clarify one point, my lord. My lord, it was never my argument that
No, you
this-
have said that
Oh.
state government accepted. You have said that. Loud and clear.
Lord, my
Yes,
submission
you have
was
said, not on while, once, on at least 3 occasions.
that I've said,
In toto.
on what context I have said, my lord. I never said that the 12th May 2017 office memorandum was accepted by the government of Arunachal Pradesh. Had it been accepted, we would not have been before your lordships. What I said is that, what I submitted, the
So
state
if-
government
if-
accept,
if you are making that submission, or rather it's a natural corollary, then the question of policy decision will still come in. It's up to the state to adopt, not to adopt. We cannot ignore this aspect formulated by the learned single judge on
My lord,
policy decision.
policy decision is
Whether you adopt or not, you cannot dictate.
what
It's up to
my,
them, and they have given
what
some-
my submission is
they have
that,
given certain reasons. Financial constraints they have specifically pleaded.
my lord, I can, I'll answer that financial constraint issue, my lord. But my submission before,
Financial constraints will be hardly have scope to argue. As an individual, how do you know about the financial constraints about the state?
my lord, 2 points. First thing, I just
No, you-
clarify the submission of my
Give me
senior
5
friend, my lord.
minutes to reply, because he's made a point very categorical,
My lord,
that 1/16/2017 is obviously subsequent to the your office
my lord,
memorandum.
that I know, my lord, that I'm not disputing that.
Then
What
how
I'm,
do you-
what I'm on to is that, my lord, 4th August 2016 office memorandum,
Yes,
that has been accepted.
yes.
That has been accepted in totality.
Yes.
That is my submission, my lord. If you accept 4th August 2016 in totality, then you not only accept this para 4.1, you accept the entire OM. Page 85, my lord.
Yes, yes.
You not only, your acceptance is not confined to para 4.1. Your acceptance is also goes to clause 11 of this OM, page 87. Lordship will kindly see page 87, clause 11. That
Yes.
further orders, in that context, my lord, I made a submission that once there is a cabinet decision to adhere or to adopt this 4th August 2016 OM in totality, how can you deny or how can you overlook the subsequent OM which was passed in pursuance to clause 11? That my submission is, my lord. I'm not saying that after 12 May, they have issued another OM. I'm not on that. Had that been issued, I would not have been before your lordships. My submission is that when you have accepted this page 2000, my lord, 4th August 2016, I'm sorry, my lord. Can you say that I will not accept this clause 11, clause 12? You are also bound by this. And to that extent, there is a cabinet decision. In that context, my lord, I made a submission before your lordship that decision is already there.
But the learned single judge in para 21 in the last para,
Yes, my lord.
it is already there that however, the dismissal of the petition will not stand in the way of implementing or effecting the formulation of so and so is already there. So learned single judge do dismiss the petition, but there is a direction or there is a observation by the learned single judge.
Yes, true. That observation, my lord, I have seen, but the entire writ petition is dismissed. When, my lord, what?
Dismissal of the writ
My lord,
petition will
I'll just
bar-
explain, my lord. I'll just explain. My lord, what I am on is that the learned single just formulated two questions. My lord, those two questions, perhaps my limited understanding, my lord, those two questions would not have come or could not have come to decide the instant issue.
No, that you have already said, that you have already
So-
argued.
Yes, my lord. Policy decision or, my lord, power of judicial review. Here they have bound themselves by accepting the earlier OM clause 11 and 12. Now, can they resile back and say, no, we'll only implement clause 4.1, we'll not go by whatever comes after clause 11 and 12, my lord? Can they say so, my lord? That would have been a relevant question to be answered by the honorable single judge. And in my pleadings also, my lord, I have formulated questions. What were the questions, my lord? I have stated all these things. Can they say so? Because the decision, cabinet decision is already there. My lord, every day there is office memorandums are coming. So this 12/5/2017, this remain unimplemented, although they have accepted that, my lord. And one more thing I'd like to place before your lordship. There is one annexure to 12/9/2015. I'll just, sir, just take it. It gives an idea as to how the fixation has to be done.
Who has carried out this exercise?
So this is part of 12/5/2017 जो OM था ना, उसका annexure है, वो central government ने दिया है.
I thought the state government had.
This is how the fixation has to be done. This is part of, my lord, that 12/5/2017 annexure 1, my lord.
Okay. Okay.
So one, my lord, similar matter, my lord,
Yes.
came up before the Honorable Apex Court. And more
Not the
particularly,
entire judgment, so as the ratio,
facts of the, my lord.
show the ratio.
Yes, ratio that comes from para 8, my lord.
8.
Yes, my lord. Even otherwise on merits also, we are of the firm opinion that there is no valid justification to create two classes. Viz. one who retired pre-96 and another who retired post-96. For the purpose of grant of revision of pension, in our view, such a classification has no nexus with the object and purpose of grant of benefit of revised pension. All the pensioners from one class who are entitled to pension as per the pension rule. Article 14 of the Constitution of India ensures to all equality before law and equal protection of law. At this juncture, it is necessary to examine the concept of valid classification. A valid classification is truly a valid discrimination. It is true that Article 16 of the Constitution of India permits a valid classification. However, a valid classification must be based on a just objective. The result to be achieved by the just objective presupposes the choice of some of different consideration treatment over others. A classification to be valid must necessarily satisfy two tests. Firstly, distinguished rationale has to be based on a just objective, and secondly, choice of differentiation one set of persons from another must have a reasonable nexus to the objective sought to be achieved. The test for a valid classification may be summarized as a distinction based on a classification founded on an intelligible differentia, which has a rational relationship with the object sought to be achieved. Therefore, whenever a cutoff date is fixed to categorize one set of pensioners for favorable consideration over others, the twin test for valid classification or valid discrimination therefore must necessarily be satisfied. In the present case, classification in question has no reasonable nexus to the objective sought to be achieved while revising the pension. As observed herein before, the object and purpose of revising the pension is due to the increase in cost of living. All the pensioners form a single class, and therefore such a classification for the purpose of grant of revised pension is unreasonable, arbitrary, discriminatory, and violative of Article 14 of the Constitution of India. The state cannot arbitrarily pick and choose.
Okay, we have read, okay.
Then, my lord, the objection of the state that there will be financial implication is also raised in this matter, my lord. There will be financial implication that your lordship will find. I'll just take your lordship's objections. I'm sorry. Page 629, my lord, para 2.1, the relevant portion, page 629. The writ petition before the learned single judge was opposed by the state government, and aforesaid classification was sought to be justified solely on the ground that, considering the financial constraint of the state was justified in granting revised pension differently to those who retired after 1196 and those who retired before 1196. It was the case on behalf of the state that, considering the financial constraint of the state, and the state was not in a position to extend the benefit of pension making the percentage given by the Government of India in its memorandum dated so-and-so to the pre-96 pensioners, and accordingly a decision was taken to extend the benefit of revised pension at certain percentage for the pre-96 pensioners and higher percentage for the post-96 pensioners. Here exactly same thing has happened. Both the differences are also there. What will happen? Okay. So here, my lord, two different criteria are followed. That, if your lordships kindly come to this annexure 1, I have given, my lord, single sheet of paper. If your lordships kindly see how the fixation is to be made, they have given. Say, for example, if your lordships take criteria that pay fixed on notional basis 1/1/2016 for a person who retired prior to 2016 is provided in formulation 1 will not get this, my lord. And revised pension with effect from 1/1/2016, how it will be determined? This 50% of last, my lord, that comes to 10255. That is clause 4 of that 12/5/2017. So here the entire change, column 12. It says after determination of everything, rise pension by multiplying 2.57, and another exercise has to be done to notionally fix as per the 7 CPC matrix. For a moment, your lordship, kindly come clause 4 of that 12 May 2017.
No, first we have to decide
No,
that.
I'm trying to, why I'm,
decide that this is applicable, then we'll go into the specs.
no,
If it's
why,
applicable, en masse it will be applicable.
true, my lord. No, why I'm trying to,
Okay,
why I'm trying to,
closing this, we have given you enough time.
why, my lord, why I'm trying to,
We are not going into the nitty-gritties.
no, why I'm taking your lordship with the nitty-gritties to make out my
We are not
point.
going to the nitty-gritties.
No, to make out my point that you cannot have two different
That we
criteria
have
for
already-
pre
that we
and
have
post,
already-
my lord.
That you have already argued, you have shown
True.
all Manipur
So-
pensioners.
That is explicit from the here, my lord. So for post 2016, they'll, my lord, fix the pension in the pay matrix. But for the pre, they'll 2.57. Two different criteria, my lord. It's not permissible, and the Honorable Apex Court also that in Manipur case has very specifically said that pre-post you cannot have. And so far as
We'll see
the,
the facts of Manipur case, under what facts it was delivered.
definitely, lordship will kindly have a look, my lord. If I, lordship one, I can take your lordships with the facts of the Manipur case also,
We have between the,
lordship. So,
when will
Lord-
resolve the judgment?
my submission, last submission is that, my lord, once you have accepted the 4th August
We have
2016,
recorded your submission.
yes, my lord, you cannot do it in piecemeal.
Then it counsel. For the appellants, two appellants, whereas-
Association,
Association, Malaysia.
only
it's an
one
association.
appellant, whereas the state is represented by the R.H. Navam Tilanet, AAG. Full stop. The hearing is concluded. The judgment is reserved.
Deeply obliged.
Okay. Your name?
But Titaba.
Sri Tita Balanet counsel for the petitioner. Prays for some time to file rejoinder affidavits against the affidavit in opposition filed by the official respondents. Full stop. Para. Ms. Wangmu, the Learned State Council, however, submits that the affidavit in opposition was filed in November 2023 itself, and therefore a short adjournment be granted. Full stop. Para. List on, we fix a date. Today is what? Today is 31st. We'll have it on, we'll get enough time. 9th of February. 9th February,
Deeply obliged.
9/2. Is there any interim order pending?
Yes,
It's mine.
Interim order,
dated 14/6.
past order extends, extended till the next date of listing.
Deeply obliged.
My lord, I beg to mention item number 19, my lord.
919.
Yes, 19, my lord.
Yes, please.
My lord, this case was earlier, it was being conducted by my colleagues, Jamo, my lord, and I have not been handed over the relevant record,
Okay,
my lord.
was 16 matter,
My lord, 16 matter, my lord, I have been entrusted recently only, my lord, so I need
where,
to.
Mr.
take-
Pangi, have you taken the?
Yes, my lord, I've taken consent, my lord.
Okay, but we'll fix the date, get over the file or take the court's file, make a copy.
My lord,
Internal matters of yours, we are not too much concerned.
my lord,
You take copies from the court,
my lord,
make a construct your, reconstruct your file.
my lord, I'll try, my lord.
Sri E. Tagum, the Standing Council Education, submits that the records of the case, that the case records are yet to be handed over to him by his colleague. Full stop, para. And accordingly, not para, continue, and accordingly, he prays for some time, full stop, para. Considering that this writ petition is of the year 2016, a short adjournment is, this court is reluctantly granting a short adjournment to be listed, short adjournment and the matter be listed for hearing on
16 February, my lord, can it be on 16 February?
16th of February.
My lord,
You take the file
My lord,
immediately,
my
okay?
lord.
Make
deeply
copies.
obliged.
Yes, my lord. I beg to mention item number 9.
9.
Here, my lord, I am yet to file counter repetitive, my lord. So,
Here for the
I,
department,
My-
power department,
my lord, I have informed other side, my lord.
Okay. on the prayer of 3, L. permit, and Standing Council power. Matter is adjourned by 2 further weeks to enable him to file counter affidavit.
My lord.
Any interim order?
No, my lord.
My lord, I want to mention item 1. I may allow to withdraw the writ petition.
Why?
Since matter has already instructed, settlement has been done.
Okay,
On ground of infractions, I may allow to withdraw.
okay. What is your name?
Arnabam.
Sri R. Nabam, Learned Counsel for the petitioners submits that during the pendency of this case, the matter has been settled settled amongst the parties. Full stop. Also heard Sri T. Jamo,
T. Tagu, my lord,
sorry,
for standing council, my name was reflected, my lord.
you're from whom? Okay.
I-
Mr. Jamo is also there. T.
He was,
Jamo is-
I'm,
okay, here you're appearing, okay.
yes, education.
Heard Sri T. Tagum, Learned Standing Council Education. Mr. Kamduk, is it there? Sri D. Kamduk, Learned Standing Council Land Management, and Miss Sri Riram, the Learned State Council, full stop, para. Writ petition is accordingly dismissed as infructuous.
Master. Master.
May your lordship, I beg to mention item number 6, and I on behalf of Advocate Ray Tapa, your lordship, he is not available today because of the demise of his elder brother.
Okay.
Therefore, this matter may be
Okay,
after
no
2
problem.
weeks.
It is submitted that Sri R. Tapa, Learned Counsel for the petitioner, he is under bereavement. Para, list after 3 weeks
Yes.
or 2 weeks?
2 weeks.
2 weeks. Okay, next.
My lord. My lord, I beg to mention WPC number 395 of 2022. My lord, this matter may be kindly listed on tomorrow for admission hearing, my lord.
Of which year?
2022.
What is the urgency?
My lord, it's a service matter. We want to dispose of this matter.
No, your want is not very important. What is the urgency?
Urgency, my lord, we want to dispose this matter, my lord.
Why? What is the urgency? It has to be taken, making mention means it has to be taken out of turn. Why?
That, my lord, I have not been informed.
You have to come prepared. We can't help you if you are not prepared with the facts. At least basic facts you should know. And tomorrow there is a meeting for some selection. Tomorrow it may be difficult otherwise. We can have the listed on next Monday. Is it okay?
Monday, my lord.
Next Monday?
Okay, my lord.
Give Monday's date.
May I proceed? Your lordship, I praise for an adjournment of item number 18.
18.
Yes, Lord. Can
Yes.
it matter may be listed after 3 weeks?
You're for whom?
I'm for the petitioner, Your lordship. I've taken concern here, Lordship.
On a prayer made on behalf of the petitioner. The matter is adjourned by 2 weeks.
Yes.
Here, my lord, petitioner was supposed to give extra copies, my lord. They have yet to.
In the meantime, what is your name?
I bomb Your lordship.
Sri
Idam.
I. Bam,
Yes.
Learned Counsel who has appeared for the petitioner, is undertakes to submit extra copies of the writ petition
Yes.
to Ms. Wangmu, the London State Council.
Yes.
May I lordship? I beg to mention item number 11 and 12, lordship. 11 and 12.
Yes,
Lordship, last evening we have received the affidavit of an opposition. So we need some time to file the rejoinder, my lord.
you're for the petitioner.
Yes, my lord.
Who has filed affidavit? of opposition?
Yes, I have.
Is some time for rejoinder?
Yes.
What is your name?
T. Darge, my lord. T. Darge.
You're not there on the record.
No, my lord.
T. Dage,
G.
London Council appearing on instruction of Sri R. Sonar.
Matter will be
Madam-
listed after 3 weeks, my lord.
R. Sonar London Council for the petitioner submits that the affidavit in opposition by the Department of RWD by the RWD has been received only yesterday. Full stop. He accordingly prays for and is granted 3 weeks' time to file rejoinder affidavit.
No.
Is there any interim order?
No.
Your Lordship, I beg to mention item number 5.
Yes,
I'm on behalf of petitioner.
yes.
Since Connecting Council, he could not turn up today. He's out of session. So kindly adjourn the matter.
You're on behalf of Mr. Sonar?
Yes. Your Lordship, kindly a fixed date may be given as we have to file a rejoinder on 19th of February.
You're not fixing that. You're seeking adjournment. We'll give you time to file rejoinder. On a prayer made on behalf of the petitioner, 3 weeks' time is granted to file rejoinder affidavit.
Okay.
Okay.
Much obliged.
My lord, I would like to mention item number 10.
10, yes.
Yes, this matter may be taken up after 2 weeks.
Then after 2 weeks.
Yes,
Why?
I have to file affidavit of, sir.
You're for the respondent,
Yes, for 2, 3, and 4.
for the university.
Yes, madam.
You're T. Gandhi,
Yes, madam.
Sri T. Gandhi Learned Standing Council. So-and-so university, you know the university's name? No? Prays for and is granted 2 weeks' time to file affidavit in
Yes,
opposition.
madam.
No interim order?
No.
May my Lordship, I beg to mention item number 2. We are supposed to file an affidavit, but
Yes.
due to sickness, serious health issues of the petitioner, he is unable to come and swear the affidavit. So sometime I be,
What affidavit? Rejoinder affidavit?
yes,
Rejoinder affidavit?
yeah, I can for some time kind of.
No, what affidavit will the petitioner file? Rejoinder? Reply affidavit?
Yes, the detail is I'm unaware regarding that detail.
That things you will not do.
Hmm.
If the petitioner wants to file an affidavit, you should know what affidavit. It's an additional affidavit, rejoinder affidavit, what? You check the records, not like that.
Yeah.
Do you have the file with you?
Yes,
Have the file rejoinder?
I'll just get back to you, sir. Your Lordship.
This is the first time we'll be taking. One has also already been.
Yeah.
Check the court records immediately. Yes,
I'd like to mention item number 27.
27.
Yes, Your Lordship, the respondent number 3 and 4 have not filed the affidavit. And so in the meantime, Your Lordship, the matter will be fixed for admission hearing.
See, you're for
Lordship,
3
I
and
am for
4.
3 and 4.
You'd like to
I
file
wish-
affidavit?
Yes, Lordship.
What is your name?
Ex-Gati.
3 X Gyati. Learned Counsel for the respondent numbers 3 and 4. Prays for and is granted 3 weeks' time to file affidavit in opposition. Yes. List after 3 weeks. Yes.
Much obliged.
Lordship, I beg to mention item number 3, Lordship.
Item number
3.
3, yeah.
Lordship, this morning I got a call from Mr. D.K. Deori. In fact, he has submitted a letter of absence also, Lordship,
Okay.
till today.
Okay,
Lordship, I'm for the petitioner here, Lordship.
okay, you are
But
with
he has
Mr. Tara.
requested for adjournment of the matter.
Mr. Jamo, your name is not there.
Lordship, I'm on behalf of petitioner, Lordship. My name is there, Lordship. Second, Jumgam Jini, J Jini.
Okay, your name is there, okay. Three, Ginny, learned counsel for the petitioner submits that he has been telephonically informed
Informed.
by the learned counsel for the respondent, Sri D.K. Deuri, regarding his absence. Full stop, para. Accordingly, list after a week,
After 2 weeks, Lordship.
list after 2 weeks. Any interim order?
No, Lordship, there is much.
Lordship, I would like to mention item number 20.
20.
Lordship, I have taken the consent of the petitioner, your Lordship. May kindly take up this matter after 4 weeks.
18 matter, why, madam?
Yes.
Actually, my lord, I forgot to bring the brief, my lord, so I have taken concern, Mr. Saikia, can it be adjusted, my lord? He said, my lord, no objection. my lord. It's a promotion.
It's
of-
lucky that you did not forget to come to the court.
Yes, my lord. That way I am very lucky, my lord.
And principal seat is having a holiday today.
Today, my lord? Because of me, my lord?
Maybe. There's some festival, Madam Murphy. Doesn't matter. Okay. Three. R.H. Nabam, the learned AAG, prays for a short accommodation on personal grounds. Post of list on Tuesday next,
My lord,
Thursday next.
any
Mr.
day.
Saikia is here around? Yes, when? Thursday? This is 18 matter. Thursday or Tuesday next, tell us. On 8th,
my lord, except Wednesday, my lord, any date. he can
8
take.
on 8 February,
8 February,
8/2.
8 February, all right.
Is there any interim order?
No.
Okay. Have you checked?
Yes, my Lordship, I'm sorry for the inconvenience.
Okay.
It's an additional affidavit.
We'll file additional affidavit.
Yes.
Why?
Because since the client is unwell and he's unable to travel and he's unable to swear the affidavit.
No,
Come-
additional affidavit for why?
Yes, I will need it.
Whoever is conversant, submit. If it is not conversant, you submit, madam.
Mm.
Is it so difficult to convey?
You know, the
What
client,
kind of affidavit do you need to file?
there are some additional documents that we would like to place before this honorable court. So
Okay.
those
Do you know
documents
that you
have to
need to
be-
take leave of the court to file additional documents? It's not a matter of right. You have to take leave. There is some.
No, no, on the last date, we had made the submission and this honorable
That was
court
allowed?
allowed. And
Okay, it is submitted on behalf of the petitioner that do an additional affidavit to bring on records certain documents was to be filed, comma, due to the ill health of the petitioner, comma. The petition number 1, there are
Petition
two
number
petitioners.
one.
Yes.
Petition number
1,
one.
comma, the same could not be filed. Full stop, para. Accordingly, comma, I straight for matter is adjourned by 2 weeks
highly obliged.
to enable filing of such additional affidavit. Okay,
Yeah, my lordship, I beg to mention item number 16, my lordship.
16 years.
This matter may be taken up after 3 weeks, my lordship. We have
Why?
to file affidavit, my lordship.
You have not filed.
No, my lordship.
Yes, Mr. Saikia, who's there?
We have taken.
On the pair made by Ms. Wangmu, learned state council. Matter is adjourned by 3 weeks to enable filing of affidavit in opposition. 16,
Obliged.
yes.
Wait, please, Lordship.
My lord, this contempt,
Yes.
my lord, I'm not appearing in contempt, but in item number this, in writ petition, I am appearing also. And for the government side, Mr. Tapani is appearing and he's not here now and he has instructed me to get the matter pass over for time being.
No, we are thinking of item number 22 now.
22.
22.
22.
22 will issue notice.
Yes.
What is the order? Where
My
is
lord, page 27.
27?
27, my lord. In this, the deputy commissioner has filed an additional affidavit
in the contempt petition, my lord, at paragraph two, page 29, my lord, he had given a specific assurance to this honorable court, and on the basis of which this contempt petition was closed, mentioning that as per assurance given,
Now, first, where is the order?
page 27.
No, no, order of this court.
Oh, my lord, yes. Page 37, my lord,
37.
37. Operative portion is page 38, my lord. My lord, may I read, my lord? Because of this assurance, we were satisfied with that assurance because that report, survey report, had such and such, learned counsel appearing on behalf of the petitioner, also had such and such. Mr. Such and such,
Where is the original direction of 3/6?
my lord,
Where is the original direction of 3/6/2021?
my lord, page 14, my lord,
14, where is the operative part,
page 14
operative part?
and page 15, my lord. My lord, page 14, paragraph 4, paragraph 3 onwards, my lord.
Yes.
So, my lord, considering the nature of the grievance raised by the petitioner, the learned counsels appearing for the contesting parties have agreed that this petition may be disposed of at the motion stage itself by directing the petitioner to submit a fresh representation highlighting his grievances within a specific time frame, and thereafter directing the deputy commissioner to
Okay, I have read this. You were given a liberty to file a fresh representation.
Yes,
And unless that representation was disposed of, the impugned order will not be given effect to. That was the order.
after my representation, they did not do anything.
So you
so
filed contempt.
I have filed contempt. In the meantime, they have undertaken that survey, and the survey report was submitted, and that survey report, along with all the annexures, in the form of an additional affidavit, was filed by the respondent
Okay.
before this honorable court.
Okay, there are.
And I being satisfied with that survey report,
Now
I
what Now what has happened now?
now, my lord, now thereafter, my lord, at page 39,
Yes.
the deputy commissioner has recommended for payment of that original, my lord, if your lordship will recollect, there was an order for payment. My lord, in that road, Tagalagam Road, there were 2-3 survey reports, estimates. Your lordship had quashed all the survey reports, estimates, and has upheld a survey report for an amount of 35 crores, something. My lord, now this amount, exact amount has been sought for payment and disbursement. Page 39, my lord.
Yes.
Now, my lord, since I am not against this report, but what my stand is that since there was a re-verification, there may be some recalculation has to be done. Some money may be added or may be deducted from this 35. What I'm saying is that, my lord, it should be done, and additional this thing, whether it is deducted or added, it should be on over and above this 35. So this, I have submitted a representation at page 42, my lord.
But where is the contempt?
My lord, he had,
You can challenge the legality, validity, correctness of this order, but where is the contempt?
my resolution submission is that in his additional affidavit at paragraph 2, he had categorically stated
Yes.
that this verification report of 18/4/22 would be taken care of while forwarding the final compensation amount. May I just read page 20, my lord?
No, he has taken care of at page 9, first paragraph.
No, my lord.
It is to intimate you that the joint survey report and estimate done on
But
6/3 for an so and so under the LL so and so, Lara 2013.
But then, my lord, the findings of this survey report has
Revised
not been
twice.
incorporated.
No, the revised, its estimate was revised twice. To report this communication may be erroneous or may be subject matter of a challenge, but there is no contact as such.
No, my lord, my civil submission is,
Have you filed a writ petition challenging this?
yes, I cannot
With
read it.
certificate that there is no contempt.
No, my-
Heard three T party learned counsel for the petitioner who by
Otherwise,
means of
Malad,
this-
let it be taken up after 23, Malad.
after,
At the number 23.
no, this is this we are closing. Ministry will examine on its own.
Malad, my respectful submission is he had assured this honorable court
No,
that he will.
we will consider your submission. The contempt is between us and the LS contempt. Learned counsel for the petitioner who, by means of this petition, has alleged willful disobedience and non-compliance of
The assurances, Malad.
the order dated 3/6/2021 passed in the original writ petition WPC 161 of 2021, full stop. Para,
And then, Malad,
it is submitted is that the said writ petition was closed by the aforesaid order by directing the petitioner to submit press representation, which was required to be disposed of by the Deputy Commissioner, Anjar District, full stop, para. As the said direction was not implemented, was not complied with, the petitioner had earlier filed the contempt case number 9 AP 2022, in which the alias contempt, in which the respondent had filed an additional affidavit on additional affidavit
29/5/23.
whereby certain assurance were made for consideration of the representation in accordance with law. Full stop.
No, Malad, not the representation. To implement the survey report.
Or to have made an
Survey
undertaking,
report that
had made
taken,
an undertaking that the survey report, where is that part?
Malad, page 29, Malad.
Wherein the following statements were made, page 29, paragraph 2. Also. Consequently, an order has been passed
Page 39.
on 22/12/2020, which has been annexed as Annexure 3, full stop. It is the contention of the learned counsel for the petitioner that the order 2/12/20 does not take into consideration the fresh survey report, and therefore the order is in violation, is not in sync as per NC with the undertaking given on affidavit. Full stop, para. This court has perused the order dated, the communication dated 22/12/2023. Full stop. In the opinion of this court, though the order maybe the order takes into account the earlier litigation and the orders passed by this court and has come to a conclusion and had given a direction for deposit of a certain amount in the account of the beneficiaries, full stop. Though the correctness of the validity of the order can be questioned, which has to be done in an appropriate proceeding, prima facie, the element of contempt does not appear to be present, full stop, para. In view of the above, the instant petition for alleging contempt is closed, full stop. At this stage, this court has been informed that a separate writ petition has been filed
The writ petition number
challenging the
44.
validity of the said communication, full stop. The said writ petition would be decided on its own merits.
Lordship may kindly pass over for some time, your lordship.
Right,
As the government advocate will appear, lordship, and he,
call him.
Is there only notice to be
after
issued?
some time, your
No,
lordship.
what is the meaning of the undertaking? We may not proceed against him in contempt, but definitely he's given an undertaking that he's going to go by the survey. The report, the communication does not appear that he has taken into account the survey, press survey. Okay, I heard Sri T. Patil, Learned Counsel for the petitioner was to challenge an order dated 22/12/2023 issued by the Deputy Commissioner, whereby a certain amount has been assessed and directed to be deposited in the account of the beneficiaries pertaining to acquisition of land. Full stop. It is submitted that there is a checkered history and including previous litigations, and in one of the litigations, the said authority by way of affidavit had made a statement that the assessment would be done by taking into consideration the fresh survey report. Full stop. The Learned Counsel submits that a reading of the impute notification would not disclose that there has been any consideration on the fresh survey report. Full stop.
Dated 18/4/2022.
Fresh survey report dated 18/4/2022.
2022.
Full stop. Let notice be issued. Returnable on. Give a date. Returnable on 19th. Is it okay? 19th February, madam, is it okay?
Lordship.
19th February. Sri D. Kamduk, Learned Standing Council Land Management, accepts notice on behalf of respondent number 1, Ms. R. Basar, the Learned State Council, for respondent number 2, and Mr. Kato. Anyone? CGC? You are a CGC? What is your name? And Sri so-and-so, Learned CGC, accepts notice on behalf of respondent number 3, that extra copies of the petition be served upon the Learned Counsel for the respondents by tomorrow.
My lord, just an observation that the pendency of this petition should not be a bar, my lord, because
Bar for?
my name is also
Bar
included.
for?
Bar for disbursement of the amounts, if they choose to deposit, but I have a right to
Okay.
because I am not.
Yes, this court, however, observes that disbursement of the receipt of the amount as mentioned in the impugned communication shall not cause any prejudice to the present petition.
My lord, in fact, this demand letter written by the Deputy Commissioner, it is on the basis of the order passed by this honorable court in writ appeal 24
Okay, we'll examine.
22.
Yes.
Lordship, now since the money has been deposited in the account of Deputy Commissioner and DLRSO for disbursement to the beneficiaries, so this may not be this disturbed, Lordship.
That is already observed.
We have not disturbed. We have not disturbed. We are saying that receipt will not cause any prejudice. They can receive this amount, but the
Yes,
challenge which they have made, that will not be affected.
yes.
Lordship, may kindly observe that this order passed today shall not be this bar for disbursement of the deposit
We
amount
have
to
not passed any stay order.
There is no stay order.
We have not passed any stay order.
Can make that observation. Otherwise, when matter is basically the authority is very reluctant.
It is further made clear that this court has not put any embargo on the disbursement of the amount in question.
Much obliged.
No, then we restructure it. Don't write the first line. This court, however, makes it clear that this court has not put any embargo on the disbursement of the amount in question, which however will not cause any prejudice to the rights and interest of the petitioner in this.
Further rights and obliged, Lordship.
In this petition.
My lordship, this matter may pass over for a day, lordships. For a day, lordship.
For a day.
Yes, lordship. My seniors have some personal difficulty to attend.
Tomorrow there is an interview, we don't know whether it will come for motion.
Yes, lordship.
Okay, motion we can take.
Yes, lordship.
Yes, what do you say tomorrow? Yes. Okay. On the prayer made on behalf of the petitioners. Matter is adjourned to be listed, matter is adjourned to be listed tomorrow.
Much obliged.
You typed this earlier. Why caveat by whom? By whom? Private respondent?
Yes, my lord.
What is the matter?
My lord, it's regarding land acquisition, my lord. Land acquisition matter.
Who are you?
My lord, I'm a company, my developer, my lord.
Okay.
The government, they have acquired, it's not acquired, the acquiring process is on, my lord. Now, I have been entrusted allotted by the government of Arunachal Pradesh to develop the hydropower project in a particular place, my lord. So,
You are the requiring company.
yes, my lord.
The payment has to be made by you.
Yes, sir. Whatever requirement I'm ready to pay, my lord. Deeply out.
Chief, I am for the petitioner.
Yes, what is this?
My lord, this is a GST matter, my lord. We have challenged the validity of levy of GST on the royalty paid to the government of Arunachal Pradesh for the exploration license that has been granted to us. A similar petition, my lord, have been filed in the principal bench also for the royalty paid to the state of Assam, my lord. The orders are enclosed.
Where are the orders?
My lords. The writ petition, my lord, page 359, my lords.
Page?
359, my lord.
Yes, what do you say? Who's appearing? One to four.
My lord, both, my lord. CGST and GST, both they have challenged, my lord. My lord,
Because GST is payable under
359.
359, my lords.
my lord, only technical issue, my lord. My lord, since the company being represented by the chief
Issues are
executive,
pending consideration in the principal bench. We're aware of that.
My lords, may I submit a copy?
Yes, 359. Yes, we have.
359, my lord.
This is by Hindustan Oil Exploration.
Yes, my lord.
Same issue.
Same issue, my lord.
my lord.
Yes, what do you say? We pass a similar order at this stage? Here, notice has been issued.
Notice has been issued and interim order has been granted, my lord.
What is the stage now?
My lords, as per the case status, there's a matter WPC 2795 of 2021, which is the principal matter, lead matter. It was last listed in December 23, where it was adjourned for 6 weeks.
Okay.
The readings are complete in that matter.
Okay.
In fact,
What, yes, what is your name?
DSEN.
May I just,
DSEN.
Listen.
my lord, subject to your lordship correction, may I just take your lordship to page number, this is page number 12, my lord, 2. My lord, it's MSU and Petrol Limited, a company register so and so, and who is going to represent this company? I think there is not mentioned, my lord. Your lordship may kindly see the cost item in the letter, my lord, page 2, my lord.
Yes.
This is a company, no doubt, my lord. But who is representing the company, my lord? And affidavit has been shown by the chief executive officer, my lord. Now, when you say company, it's governed by the board of directors, my lord. And where is the authority for that, my lord? And these are some technical issue, my lord.
My lords, chief executive officer is the
He's not a company owner, my lord. He just employee of your company.
You are correct, but these are very technical matters in a civil proceeding.
Yes, I said, subject to your lordship.
In a writ
Technical
proceedings, you
issues.
may not be insisting on this, but you are correct.
Madam,
Board
yes.
resolution has to be annexed.
Yes.
That is the minimum thing. Not be insisting, but board to authorize
Yes.
a particular officer. Is there, there has to be a board resolution. Next
There
time
has
you
to be, my lord.
come equipped with that board resolution.
Possibly it's not annexed, my
No,
lord.
but
There-
you, it definitely will have,
It should be, my.
because company filing a litigation without a board resolution may not be, cannot conceive of. Nonetheless, okay. Third, three, decent. Your name is not there.
Mr. State name is not there, madam. Sri and Mr. Rahul is there.
Okay, doesn't matter. You want to record or not?
My lord, my it was submitted, the registry has not reflected it yet, I am informed.
Okay. Okay. Ahad Sri decent learned counsel for the petitioner. Full stop. The petitioner, which is a company, is aggrieved by the GST notifications comma, more particularly, the entries made therein and also the entries in the scheme of classification of services by which GST has been sought to be levied on the royalty sums. Full stop. It is submitted that similar issue is pending consideration before the principal bench of this court, and one of the orders has also been annexed to the writ petition. Full stop. Para. Let notice be issued, returnable by 4 weeks. Yes, three so and so. Learned for year 4,
4 and 5, madam.
1, 2, and 3.
1, 2, and 3.
So and so, learned CGC accepts notice on behalf of respondent numbers 1, 2, and 3. Whereas Sri R.H. Navam, the learned AAG, Arunachal Pradesh, accepts notice on behalf of respondent numbers 3 and 4.
No, 4 and 5.
4 and 5, right? 4 and 5. Extra copies be served upon them by tomorrow. Full stop. Considering that in similar cases, an interim protection has been granted, comma, this court directs that till the next returnable date, comma, the petitioner would not be required to pay the service tax oblique GST on the royalty component to the state of Arunachal Pradesh. The aforesaid interim order would, however, be reconsidered on the returnable date. List on, let's say 4 weeks. List on 1st of March
1st March, madam.
2024. Serve extra copies, madam. Grateful, madam. Yeah. Item 4.
Or lordship, this matter may be closed, lordship.
4, yes.
Lordship, this matter may be closed, lordship.
Maybe
May be closed, lordship.
Why?
Lordship, here, Lordship, before filing of this writ petition, Lordships, there, the respondent authority, Lordship, are not provide the DFR, Lordships. After filing of,
Provided?
they did not provide the DFR, Lordship, detailed project report of the tender, Lordships.
DPR?
Yes, Lordships.
Okay.
So we file, Lordships, without DFR, Lordships, they're going to construct the water tank, Lordships.
Dam. Not
Tank,
there.
tank, Lordships.
For extraction of drinking water.
Yes, Lordship.
Okay, tank.
Yes, Lordship. Yes.
Now it has been
Yes,
completed.
Lordship. And now in process,
Okay.
Lordship, on this.
Sri G.
this
Bab, heard Sri G. Bab, learned counsel for the petitioner. Also heard Sri Priram, the learned state counsel, as well as Sri K. Lolan for
Respondent number 6 and 7.
respondent number 6 and 7. Full stop. The subject matter of this writ petition was construction of a project of water tanks.
Your Lordship, scheme, Lordship, water tank, scheme, JJ scheme, Lordship.
Regarding, is it concerns a scheme for construction of water tank?
Yes, sir.
And according to the petitioner, comma, there was no detailed project report.
Yes, sir.
Full stop. However, it is submitted that during the pendency of this writ petition, comma, the construction has been made and the scheme has been implemented.
Yes, sir.
Full stop. This court, the United Council accordingly submits that there is no, there may not, there submits that there may not be any live cause of action to be further adjudicated. Full stop. Para. Accordingly, the writ petition is closed.
Mashallah.
Children, yes. Mr. Genie, what is this?
My lord, this is the land compensation matter, lordship. Lordship has already dealt similar situated case, lordship. It's clearly covered by this honorable court's judgment, lordship.
I've yet to file affidavit, my
Lordship,
Is it covered?
1.5 year back,
Is it covered?
lordship, it is covered,
lord.
lordship.
My lord.
Huh?
I have no idea, my lord. They have not served.
It is covered, lordship. I have the judgment with me.
If the consent was from her, that it was covered, then we'd have disposed this of.
Lordship,
No, but her consent should come. She's not
lordship,
aware.
I can
We'll
confirm.
have this on Monday. Go through the judgment.
Okay.
Okay. Heard Sri J. Gini, learned counsel for the petitioner, who submits that the issue involved is with regard to land compensation. Is it regard to compensation for land acquisition?
Okay.
And the issue is covered. And according to him, comma, the issue is covered by a judgment of this court. Full stop. Para. Ms. Wangmo, the London State Council, however, submits that she is not aware of the said judgment, and the state is yet to file the affidavit in opposition. Full stop. Para. This court is you're for?
I'm for respondent number 2, Lordship.
Also heard the D come to London Standing Council. Management. Full stop. Para. This court is of the view that if the issue is covered, comma, the requirement of filing an affidavit in opposition may not arise. Full stop. Para. In view of the place this case on Monday next, or on, I give the date, 5th, full stop. In the meantime, comma, the London State Council will examine
Lordship.
the aspect of the earlier judgment, which has earlier judgment, which the petitioners are relying upon.
Much.
Give her a copy or give her the details.
I'll provide, lordship. I'll provide.
Petitioners.
May please, Your Lordship.
Yes, yes.
My lord, the petitioners herein, they are extension officer rural engineering. They were initially appointed in the year 1996, 97, 98, 2003, 2007. Now, their next promotional post, as per them, is assistant project officer technical. That is the post in the next higher pay scale. Now, there is no recruitment to travel to that post. No recruitment rule. No recruitment has been framed. Cadre strength is 9.
Cadre strength in the higher post.
Higher post is 9. In the meantime, the government of Arunachal Pradesh issued an office memorandum that they will absorb this executive engineer, rural
Extension of.
extension officer, rural engineering to DRDA upon completion of certain number of residency service, my lord. And that will be done by virtue of a selection committee. Now, without holding any selection committee, in absolute pick and choose manner, persons junior to us were taken to DRDA in the post of, my lord, assistant project officer.
But that.
And the irony.
No, that was by the means of deputation over.
Deputation, my lord, purely on deputation, but that also in the office memorandum says there has to be a selection committee meeting,
Even for deputation.
even for deputation. Fine. That they did not do. Pick and choose manner, person junior to us were taken. Now the irony is that now a decision is going to be taken that DRDA will be merged with the rural engineering department. Now, persons junior to us who are already traveled to the higher pay scale as APO,
Were you given the option at the time of deputation?
no, nothing. Because they are to hold a selection committee going by, yeah, they'll have to see the seniority position, then they will take. Absolutely pick
Who's
and choose.
appearing for the department? Department.
Yes, my lord.
RD, rural development.
Yes, ma'am.
What-
What
what is
happened by order dated 21/8/2023, my lord? I was directed to seek some instruction, my lord. So, my lord, I am furnishing some instruction, my lord.
Yes.
Yes, ma'am.
What is it? Tell us.
My lord, it is regarding the actual stage, my lord. Status of this,
Yes.
RR, my lord. It
Okay.
is pending before the, my lord, administrative reforms department, my lord, AR department. And the draft RR is also, I have submitted, my lord.
No, you frame the RR, you
Yes.
implement the RR, that's a different aspect.
Yes.
What he is trying to project is that persons in his cadre or
Yes.
junior to him
Yes.
were taken to some other
DRDA.
DRDA, some other agency,
My lord.
in which they were not given a fair chance,
My lord.
whether they would like to go. If a fair chance was given, they opted not to go. Matter would have been slightly different, but still that matter would arise for adjudication,
My lord.
because that was not made open to them that the DRDA subsequently will be merged with this particular,
Yes. sir.
the
RD
parent wing.
Yes, sir.
So even ignoring or overlooking that aspect of the matter for the time being, here the projection is that now DRDA is supposed to be merged.
Yes, sir.
So person who were junior to them in their parent cadre
My lord.
would come back and in one organization as seniors.
If
You have the RR, that's a different aspect, go by the RR.
If they merge, my lord, there will be serious chaos in the entire thing.
RR will govern future promotions, all everything, but
Yes, sir. My lord, in that case, my lord, the
now
department.
what are
seek
you
the-
challenging?
My lord, firstly, my first prayer is that you frame a recruitment rule.
They are doing. But will
Till
it-
date, they haven't done it.
But will that take care of your grievance?
Yes, and.
Now, will that take care of your grievance?
Yes,
How?
Yes.
sorry, my lord.
Framing of a recruitment rule, will that take care of your grievance?
At present, no.
No, it cannot.
At present, no, my lord.
So how what relief
Because-
are you seeking?
My lord, I am seeking that my prayer, my promotion to the post of APO may be considered. And third prayer is that the seniority, the persons who went DRDA to DRDA, they should not be placed above us in the final seniority list.
Who are for the private respondents?
That is not the prayer, my lord. There is the private respondent. Page 23, my lord. The prayer is.
In prayer 3, we made a prayer to prepare an updated seniority list.
That,
But last
that we can
seniority
do,
list
but-
was prepared in the year
You
2015.
have not made those incumbents parties
Yes,
who had gone on deputation or who will steal a march, you apprehend at least.
yes.
They will steal a march on the senior.
Till date, since till date, this merger has not happened. Merger of DRDA and
No,
so
that
and
is your
so.
main apprehension. The merger, once the merger happens, somebody.
If merger happens, my lord, and seniority list is finalized.
When are you, is it really on the
It is under-
pipeline?
That's
Yes,
the-
yes, my lord. It is under consideration by the government, my lord. It is not in our hand, my lord. The cabinet will
take the decision, man.
Mr. Das, you are what? Extension?
I am Extension Officer, Rural Engineering Department,
Extension Officer,
Rural Engineering,
RD. Rural-
RD, my lord.
Yes, ma'am.
Rural Engineering Department.
Yes, my lord.
Part of,
RD, my lord.
RD.
Means, my lord, engineering wing, my lord. RE, engineering.
RD Engineering Wing.
RE.
RE, my lord. RE, Rural Extension Officer within bracket RE, my lord.
The deputation was made to DRDA as what?
In various posts, I just,
No, you said your juniors were taken there.
yes, yes, my lord.
Joined as what?
Joined as, my lord, Assistant Project Officer within bracket Rural Engineering.
Assistant Project Officer, RE.
Yes,
These are in the same pay scale.
and there is another,
These are in the same pay scale.
yes, my lord,
Same pay scale.
same pay scale.
Now, what is the problem?
Another, my lord, nomenclature is that Technical Assistant IWDP and Technical Assistant RE. In these two nomenclatures also, persons are taken from this
Your
Extension
cadre,
Officer.
Your cadre, okay.
RE.
Now, what is their deputation is not the problem. Now, what is supposed to be done? They are supposed to amalgamate DRDA, merge
First
with.
of all, yes, that selection, they did not hold any selection as per the OM. Now they are going to.
No, that is not a heartburn for you because they are getting the same pay, same cadre, or same pay scale.
Higher pay scale.
You
This
said
is
the
a-
same
this
pay
is-
scale.
No, this is APO RE is a higher pay scale, my lord. That is equivalent to APO technical. That is
No,
the.
no.
I'm
You
sorry,
said that you are an extension officer RE.
Yes,
Certain extension officer RE who are junior to you were deputed to the DRDA,
DRDA in the post of
assistant
APO.
project officer.
Yes, that is a higher post.
You said same skill is higher post.
Higher post, my lord. I'm sorry, my lord.
All these are higher post.
All these are higher post, my lord. That's where the heart burning is, my lord.
higher
They were
post.
supposed to take the persons from EO by holding a selection
So
committee.
that is the subject matter of challenge also. How it could have taken them.
Yes, that is. we
Aren't
have
you
to-
required to make those incumbent
No,
parties?
fine, my lord, you have taken them, we have pleaded those things, my lord, to, my lord,
What is your prayer here?
facilitate our
Page 23,
You should
man.
have
page
struck-
23.
We thought you had a good case. You should have structured your prayer. Page 20.
2-3, my lord.
2-3, yes.
Basic our heart burning is that, my lord, if you bring those persons back to the EO cadre,
Frame
okay,
RR rules. In the written- No, they are framed RR.
not frame,
Not
not
they
yet
are
frame.
given on record.
No, this is draft, I think, my lord.
Draft,
This is draft.
It is only draft will be followed by a final.
Ultimately, RR has not framed. That is, if RR is framed, my prayer number 1 is taken care of. And consider the case of the petitioners for promotion.
That we
that
can,
prayer
after
to-
framing of the RR, we can say that.
Yes.
Fine,
Their course of action will lie on it.
You
But-
could have or you should have. If you are supported by pleadings that this deputation was not done by giving you a chance, you could have at least put it on challenge whether we agree with you or not. That's a different
In
matter.
the interim prayer, my lord, we have made a prayer that not to absorb this EORE in the who were taken to higher post of APO
Without
technical.
making them parties, this will be difficult.
uh,
How many of them are there?
Not lot
Not
many,
many,
my lord.
not many, I think,
Uh,
not many. The idea, how many will go? Maybe around more, not less than 10, I think, not more than 10.
Around 15-20 will be there.
Heard Sri H.K. Das, learned counsel for the petitioner. Also heard Sri B.P. Shah, learned counsel for the learned counsel for the department. Full stop. Sri Picha. Under the learned standing council has placed on record, has submitted that the draft recruitment rules under the title within inverted comma, the assistant project officer within bracket technical bracket close comma, group A comma, recruitment rules 2022 has been prepared and the process is on to finalize the same. Full stop. The document pertaining to the movement of the file has also been placed on record. Full stop. Para. How much time?
4 months.
For finalization?
Finalization, but it is in with the air department, Madam. So we don't have any.
He also submits that presently the matter is with the Administrative Reforms Department.
Yes.
Which department, full stop. Para. This court is of the opinion that if the recruitment rules are framed in accordance with law, comma, the principal grievance and the relief against serial number 1 and the principal grievance which is connected to the relief would be redressed, full stop. So far as the other reliefs are concerned, comma, this court would, those relief are still open for consideration, which would be done by this court at the appropriate time. Full stop. Para, list after 3 weeks?
3 weeks.
You want a date? You want a date? Or what?
Yes, I'll just,
We'll give a 4-week date. Let them
After-
list on. We have a date for you. Tell us the date. List on 4th of March.
photo. No, only one apprehension I have, they're in the process of this merger. If these persons come, our seniority will be disrupted.
You file, come before us, file a miscase, we'll do something.
My lord, fine. Deeply obliged.
But in that case, again, making of parties will come.
Yes, that lordship is correct.
Once we.
Highly obliged.
You'll see state respondent as well as the private respondent, they are yet to file their affidavits.
Yes, private respondent who's appearing.
Mr. O Modi, I think. O Modi, Lordship.
O Modi. Who's there? Anybody with Mr. O Modi? Yes, your affidavit.
Lordship, we have sent many reminders.
Now, if you are unable to find, file your affidavit, we'll, pick this for admission and go ahead. Affidavits in opposition have not been filed either by the state respondents or the private respondents. Full stop. Para. This for admission after 3 weeks. In by which time, comma, the affidavits may be filed. Full stop. It is however made clear that no further time would be granted to file affidavit.
Lordship, interim order is there, Lordship.
Para,
That may be
interim order passed early to continue till the next date of listing.
Highly obliged.
Mr. Chanda, for which case? You are sitting since long? Last item?
Yeah.
Hearing matter?
Hearing matter.
Who is on the other side?
I have prayer engagement. I requested him. Today, my serious part may be allowed to be done, and tomorrow I'll place my
Tomorrow there is an interview. Tomorrow, second half, and these are hearing matters.
hearing matter.
Why you have some difficulty today?
Yes. Today.
So you prepare yourself during the recess. It will not take much time. If you want the hearing to be done, we are here for hearing. But on piecemeal basis will be difficult. And he has come from
No, I did.
outstation.
Therefore, I just.
If we start, we'll complete it today.
This issue is already settled by our principal bench.
What is the issue?
They are claiming that there should be fitted with the old pension scheme. Because the recruitment process was over in the year 2007. And they have delayed the appointment. So on this issue, my lord, several judgments have been Delhi High Court, our principal bench, Delhi High Court, Uttarakhand High Court, settled this issue. I have annexed all the judgments.
They want to have NPS.
No, they have, my lord, they want,
To
yes,
enforce
yes, my lord. That was the cut-off date of 1/1/2008. In central government, the cut-off date that was introduced in 1/1/2004.
thereafter a lot of
The issue
litigations are there.
would
This
require
issue is-
some deliberation. Are you prepared or not?
I'm not that prepared to put.
Not that prepared.
Therefore, I'm just.
You have a
requesting.
formidable
But
opponent.
judgments are there, my lord. In the writ petition itself, I have it closed. I feel sorry as my senior has come from outside. Therefore, I'm requesting you.
He can come again. That's not a problem.
Day after tomorrow also, I'm not.
Day after tomorrow.
Yeah, any other date?
Okay, let us come back at 2 o'clock. Let's think what can be done.
Fine.
There are a few more matters.
Mine.
It is submitted
Lordship.
that pleadings are complete and the matter can be taken up for admission. Full stop, para. List for admission after
3 weeks. And in the meantime, also there is an interim order.
Para interim order passed earlier to continue till the next date of listing.
Deeply obliged.
Lordship, some time may be given to file affidavit here, Your Lordship.
Yes,
Yes.
and Mr. Kamru, you have filed?
No.
Both of you, you'd like to file or not?
No, I'll be filing.
On the prayer of
Right.
Ms. R. Basar, London State Council,
So challenge.
3 weeks time is granted to file affidavit in opposition.
Obliged, Your Lordship.
All right. My lord, very confusing situation has arisen. But this is pertaining to an allotment. I was allotted a plot of land indicating in the sketch map, indicating its approach road. On both sides, it was allotted to somebody. But now that has been closed. They have encroached upon that.
The land, the road,
The approach road.
okay.
Other than that, there is no other approach road. Therefore, I have submitted to the Deputy Commissioner that I may be given an alternative plot that's 786. Now, they are saying that 786 cannot be allotted. And they are also not suggesting anything whether I will be given another plot or not, or whether there will be an approach road. Well, I was allotted base 15, my lord. This is my allotment order. My lord, the sketch map is at page
But you have
17.
not taken fresh steps upon response number 3. Have you seen the office note?
My lord,
You are supposed to take fresh steps upon the response number 3. You take fresh steps.
the technical issues has come.
Office
Otherwise, my lord,
note dated 30/1/2024. This yesterday's office note, 31/2024 reflects that fresh steps for service of notice upon response number 3 have not been taken. Full stop, Sarah. 3, key party, learned counsel for the petitioner is granted 2 days time to take fresh steps upon the respondent number. For fresh steps for service of notice upon the response number 3 as directed wide order dated 5/10/2023. Para, as, no, I said, as directed, comma, steps be taken by registered post QTD. Take steps, at least after 4 weeks, along with service report.
obliged.
Yes.
Lordship, I think it's already covered case. Just I've gone through and I repressed myself. Yeah, the selection process is started before NPS has been applicable to state of AP. And selection concluded or the final appointment was made after the NPS has come.
Okay.
Now question comes whether the earlier scheme, old scheme will applicable or new scheme will applicable.
Correct.
And that regal lordship, one various judgment of the High Court. If lordship come to page 161 lordship. This
This is also your submission.
yes, judgment passed by the division bench of this Honorable Court.
Okay.
Where lordship this categorically it has been held that lordship that since when vacancy arose, at that time what rules was applicable to them.
Okay.
So then on that principle, lordship
Okay, then it will be easy for us. Let us dispose this
lost.
in terms of the
161.
My lord, for your lordship, assistant, I have, the judgments were enclosed with the writ petition, but I have highlighted all the para, including our High Court judgment, division bench judgment, and other judgment of the Delhi High Court, and
not necessary. We have a DB of our High Court. We'll refer to that.
the first case. The first case, other judgments are there. First case, your lordship, para 23, 24 onwards. Because our selection was over.
Heard Sri M. Chandra, learned counsel for the petitioner. Also heard Sri S. Tapin, the learned senior government advocate, Arunachal Pradesh. Full stop. Para. Please have your seat. "95 numbers of petitioners have joined together in this writ petition with, amongst others, the principal grievance relating to their pension. Full stop. The petitioners are working as head warden oblique jail warden in the jail department, which is under the Inspector General of Prisons of the state of Arunachal Pradesh. Full stop. The grievance of the petitioner, as indicated above, is by placing them to be covered by the why national pension is new pension scheme. Is it not new pension scheme?
New pension scheme.
Why
New
have you
pension.
written national pension scheme?
Typographical mistake. Sorry, Lord. New pension scheme.
By the new pension scheme. Full stop. To be more particular, the grievance is against a communication dated 22/7/2021 issued by the authorities, by which it has been laid down that employees who were appointed on or after 1/1/2008 would be covered by the NPS. Full stop. Para. The case of the petitioners is that the recruitment process through which they were inducted in the services was pursuant to an advertisement dated 19/3/2007. Full stop. The petitioners had participated in the recruitment process, which had consisted of various segments, including physical fitness and interview. And accordingly, a merit list was published on 14/12/2007 by notifying 100 numbers of selected candidates for the post of jail warden. And in that list, the names of the petitioners were included, full stop. Consequently, the petitioners were appointed on 15/2/2008, full stop.
Lordship, they were appointed on 3/3/2008, Lordship. Offer letter was given on
15/2/2008. Formal order is next, my lord, 3/3/2008.
Okay, and they were offered, they were issued offer letter of 15/2/2008, subsequent to which they were formally appointed, full stop. The Finance Department, however, had issued a notification dated 17/11/2007 by which the new pension scheme was introduced with effect from 1/1/2008, full stop. It stipulated that it would be applicable to all new entrants to the state services who were appointed on or after 1/1/2008, full stop. Para. It is the case of the petitioner that their selection for appointment was prior to 1/1/2008, which is the cutoff date as per the notification, and therefore they are entitled to the benefit of GPF and should be covered by the old pension scheme under the CCS within bracket pension bracket close rules 1972 in terms of the OM dated 17/2/2020 issued by the Department of Pension, Government of India. Full stop. Para. 3. Chanda, the learned counsel for the petitioners, has submitted that the cutoff date is to be examined from the point of view of the date when the vacancy which was existing was thought to be filled up, full stop. He submits that there is no manner of doubt that the recruitment process was initiated on 19/3/2007, which is much prior to the cutoff date of 1/1/2008, full stop. He submits that even the select list was dated 14/12/2007 and the appointment of the petitioners were incidentally made after 1/1/2008, which should not deprive them of their entitlement to be placed and governed by the old pension scheme, full stop. The learned counsel for the petitioners have relied upon a number of judgments in this regard, which are as follows. Judgment, huh? Yes. Full stop. Para. Do judgments of various high courts. This court has perused the aforesaid judgments, and amongst others is a judgment passed by a division bench of this court in WPC 7369 of 2021, within bracket Sanjay Kumar and another versus Union of India and others. Full stop. The division bench wide the judgment dated 4/2/2022, which was dealing with a similar issue, which was in connection from an order passed by the Central Administrative Tribunal, had held that it is the date on which the recruitment process was initiated, which would be crucial to determine as to under what scheme, which scheme the appointee would be covered. Full stop. For ready reference, the observation made in paragraph 19 and 23 of the said judgment are expected herein below. Full stop. The rest of the judgments are in the similar line and need not be elaborated. Full stop. Para. Sri Estapin, learned senior government advocate, Arunachal Pradesh, fairly submits that in view of the law laid down by the Honorable Division Bench, which has attained finality, and also the other case laws referred to on behalf of the petitioners, there would not be much scope to take a contrary view. Full stop. Para. In view of the aforesaid facts and circumstances, Para. This court has noticed that there is no ambiguity with the factual position that the recruitment process was initiated. Wide advertisement dated 19/3/2007, which would obviously mean that the vacancies in which the petitioners were appointed were existing at that point of time. Full stop. Even the final select list is dated 14/12/2007, which is prior to the cutoff date of 1/1/2008, and it is a matter of mere chance that the petitioners were not appointed immediately on publication of the select list, but after 1/1/2008. Full stop. This court is of the unhesitant opinion that the mere fact of appointment, that the date of the appointment would not be crucial, and the crucial date is the date on which the recruitment process was initiated, which admittedly is prior to the cutoff date. Full stop. Para. In view of the above,
And
this
delays
court
occurred on that. Delays occurred. One of the ground in every judgment taken, delay in appointment in all the cases taken.
Here there is not too much delay also. 14.
There's not too much delay.
There is not delay.
Only 18 days
18
delay.
days, there is no delay. in view of the aforesaid discussion, the present writ petition, the instant writ petition is allowed. And the impugned communication dated 22/7/2021 is interfered with, and consequently, it is directed that the petitioners be covered, petitioners be held to be covered by the old pension scheme, and benefits thereunder be granted to them in accordance with law.
Deplorable. Okay.
This is the list. You just take the list. We are only quoting from this judgment, 19 and something.